So welcome everyone to this class about civil liability in artificial intelligence. The topic of today's class is very relevant, so much so that even if you never heard about the regulation of advanced technologies, you certainly saw on some newspaper or magazine or news on TV as well, people discussing civil liability in artificial intelligence or robotics or advanced technologies in general. The very common question is, who pays for damages when something goes wrong? So we'll first have an introductory class where we'll be presenting the very basic concepts about civil liability and artificial intelligence, and then there will be a second one that you're free to choose whether to watch or not, where we'll dive in greater details into the European regulation of civil liability for advanced technologies. So let's start with our introduction. Today I would like to tell you about what is civil liability. I assume that not most of you has a legal background. Then I will address a very fundamental and radical question whether AI systems or machines in general should be deemed agents and therefore, at least under certain conditions, could be held directly responsible for the harm they might cause, and I will exclude this possibility. And then I will introduce very briefly the current existing, applicable as of today, regulatory framework at European level that you should all be aware of if you are interested in developing advanced technologies, if you are researching about advanced technologies, or even more so trying to bring innovation to the market or using innovation in your own business activity. So, but let's start with first things first. What is civil liability? Civil liability is one of the forms of liability regulated in each and every legal system that tries to address a fundamental question: who should pay for damages? So we all know that when we interact in our society, we may give rise to damages, harm one another in various ways. Most of the time it's definitely not intended. You drive and you crash into another vehicle, or as a professional you make some mistake in the fulfilling of your performance and end up causing somebody harm. And the very fundamental principle is that who causes harm needs to compensate that harm. And this is the realm of civil liability. So basically civil liability establishes who needs to bear the economic consequences of an accident. In some cases you might cause an accident and be called in to respond for the consequences of that accident, to make that person whole, to compensate through the payment of a sum of money that should put the harmed party in an equivalent position to the one he found himself before you harmed him with your behavior or conduct. And in some other cases you might still be responsible for the harm caused, but your liability might be excluded by the legal system, by the regulation that the legal system provides. So a viable example would be self-defense. If you harm somebody because you were in the first place attacked, you will not respond for that damage because you acted in self-defense, and that is a justification for the harm that you have caused to the other person, and so you're not bound to compensate that harm. In other cases, you might be called in to compensate for harm that somebody else caused. So if you're a parent, you might be called in to compensate the damage that your child caused. Why so? Because you're the adult who is responsible for the supervision of that one child. There are indeed jurisdictions where that is not the case, but they're very rare. In the most countries, in the most states, you would be, as a parent, called in to compensate the damage caused by your own child, as well as if you're an employer, for the harm caused by your employee working in your name and in your interests according to the powers you have granted them. So really civil liability rules are a broad set of rules that are present in each and every legal system, and there's typically a general rule of liability, which is typically a liability based on fault. on the fault of the agent, meaning that you can establish that the given agent could have acted in a different way, and if he did so, he would have avoided causing harm. And that different behavior could have been demanded of that person. So you drive exceeding the speed limit on a public road and you cause an accident, you run over someone that is crossing the road. It's clear that if you maintain the correct speed, you would have avoided that accident in the very first place. Therefore, you might be deemed at fault. You have violated the street code, a regulation establishing a liability, a limit for your speed in that specific road. But at the same time, you have also failed to comply with the standard of diligence that would advise you to pay attention under those circumstances, behave differently, be more accurate, and avoid causing harm in the very first place. However, as I said, civil liability rules are always a broad spectrum of rules, and in each and every legal system there are also dedicated norms that only apply to specific cases. Typically, we may find dedicated norms establishing the liability of a car driver, of a car owner. Very often car owners are objectively liable for all the damages their vehicle may cause, meaning they are responsible even if they are not the person that is behind the wheel driving the car. And there are liability rules that are dedicated to teachers overlooking their pupils, parents, owners of animals and things that might be dangerous when used. There are dedicated liability rules for certain professions. Typically, very often in many legal systems, the medical profession is separately regulated because many legislators in the Western world in particular are aware of a very dangerous phenomenon that is defensive medicine, whereby medical practitioners, in the fear of being excessively sued by patients that are not fully satisfied with the effect of a given treatment on their health and overall condition, might decide to prescribe a lot of tests, analysis, medicines that are not strictly necessary, are not even really relevant, but primarily with the purpose of preparing or necessary evidence to limit their exposure in terms of liability should something play out wrong or not as desired. So we typically have dedicated liability rules for medical practitioners that tend to shield them from excessive liability claims and often funnel liability towards hospitals and other structures rather than the single practitioner himself. We typically have dedicated liability rules for capital markets where there are potentially relevant liabilities by intermediaries that operate on such capital markets in their own interest and in the interest of non-sophisticated investors. So it's very hard to enumerate all the potential liability rules that are present in each and every legal system. It shall suffice for the moment to say that each and every system regulates civil liability. Each and every legal system typically has a general civil liability rule that is fault-based, whereby in order to establish the liability of the agent, you have to demonstrate that there indeed was a damage, that the conduct of the agent caused the damage, so that there is a causal nexus between the two, and that this person is at fault, as I have already explained. But there are also a number of dedicated liability rules, and some of those liability rules do without fault, in the sense that the liability is established on objective grounds. A very relevant case is that of product liability, but we will get into that in a moment, because that is indeed the most relevant piece of legislation today existing at European level that would certainly apply to all sorts of AI and advanced technologies in general. So liability can also be established on objective grounds, and fault, despite being the general rule, has many exceptions, many relevant ones. And in the field of advanced technologies, those exceptions are, as of today, the prevailing traits, the prevailing rules that define the entire legal framework. And we'll get back to that in a moment. But the fundamental question that everybody asks when addressing advanced technologies and civil liability is, should we consider advanced AI systems, advanced robots, or other forms of advanced technologies as agents, therefore directly responsible for the harm that they might cause? And the short answer is no. But we need to dive a little bit into this debate to clarify the overall framework. Many philosophers and some lawyers maintain instead that AI system or robots and machines more broadly might be held responsible for the damage they cause. The reason why they say so is that machines are perceived to be autonomous to some extent. This is potentially what is typically understood as the qualifying trait of AI. Even this should be challenged to some extent. But very many people do believe that the autonomy of a machine causes a paradigm shift whereby you can no longer hold the human being that programmed or conceived or deployed the machine responsible for the damage that that machine would cause during its functioning. However, this idea is quite inaccurate, both on technological grounds, philosophical grounds, and legal grounds. We do not have enough time to dive into all of these aspects, but I'll provide you with some brief explanation and some intuitive remarks. The first one being, autonomy is a very broad and to some extent vague concept. What philosophers and lawyers understand as being autonomous is very different from what an engineer would understand as being autonomous. And for the purpose of establishing liability, I believe it is necessary to start with philosophy and say that we could distinguish two alternative notions of autonomy. Autonomy in the sense of strong autonomy that equates the autonomy of a full-fledged, adult, rational human being, and weak autonomy. Weak autonomy as the ability to intelligently interact with the environment and operate without constant human supervision. Now, it is clear that as of today, there is no technology whatsoever that displays strong autonomy. There is no machine that is capable of identifying and selecting its own goals and decide freely how to pursue them. There is no doubt about that. Machines, as of today, can only fulfill and perform the duties and objectives that human beings have set for them and have created them for. So no machine existing today displays any form of strong autonomy. If strong autonomy was indeed reached, we could deem machines as moral agents. An example would be if I could tell my Roomba to clean my floors at home, and Roomba would say, you know what, it's a sunny day, I'd rather take a stroll in Pisa and enjoy a nice ice cream with my robot friend next door, rather than clean your floors. In that case, we could possibly argue that Roomba is indeed autonomous in a strong sense. But we do not want such robots in our society, because we want robots to function towards our end and do what we have programmed them to do. So it's clear that we do not have that. That would indeed justify treating a machine as agents, but that would even simplify the task of lawyers, because we could simply apply the existing legal framework, and the existing legal framework would also provide the necessary incentives to optimal behavior to the machine. Because in fact, one of the functions of civil liability is that of inducing the desired behavior on the side of the agent. So I respect the speed limit on a road because I am afraid of being fined, I'm afraid of being held responsible should I cause an accident. I put all of my skill and attention in performing my work, my intellectual work, because I do not want to be held responsible. Also because I enjoy my work and because of my reputation, but also because I do not want to be held responsible. So Liability rules have an ex ante effect of inducing the desired behavior on the side of the agent, but that is dependent upon the fact that the agent can be scared or can be influenced through the fear of the sanction. A machine that is not aware of its existence would not be scared from the fear of a sanction. Short of that, short of strong autonomy, weak autonomy is what we see in different degrees among existing technologies and reasonably foreseeable technologies, and those technologies that are currently being researched and would reasonably emerge within a certain amount of time. Now, those weak autonomous machines definitely do not satisfy the criterion to be deemed an agent, but they're just a tool in somebody else's hand. So that is the case of the smart thermostat that some authors use in their example. I'm citing an article by Luciano Floridi where he claims that a smart thermostat capable of changing the temperature in a room could be deemed an artificial moral agent if only he could cause harm to human beings living and habitating the room in that very moment. But I disagree completely, and for the reasons that I have just explained. A smart thermostat is only functioning according to the algorithm it is programmed with to regulate the temperature in a room. It cannot be blamed for what it does. Somebody else programmed it that way. It's not really free to choose what it is doing, and it's just functioning independently without human supervision, but without displaying any form of strong autonomy. And moreover, any sanction, even a criminal sanction, like depriving the smart thermostat of its freedom, which it doesn't possess in the very first place, or even death penalty, the destruction of the system itself, would not be able to exert any influence on the behavior of the thermostat ex ante, and would not induce the thermostat ex ante to be more careful or more respectful of the human beings that are within the room. So even the purpose that typically a legal system fulfills cannot be applied in any way that would make sense if we considered such kind of advanced technologies like those that are existing today and like those that are foreseeable as agents. If one day, 2 centuries from now, we'll be able to conceive fully artificial life, so a system that exists for its own sake, that is capable of pursuing its own interests, if we aren't going to be dominated by that system, we could consider treating that system as an agent and attribute it with rights and obligations. But as of today, we're safe to say that there is no way autonomy justifies such a conclusion, nor does it the ability to learn. The other element that is often recalled is the ability to learn, which leads to some extent to the unforeseeability of the outcome on the side of the programmer, producer, or creator of the system. But let's take one example into account that has been developed by a famous philosopher in this debate already some years ago. His name is Andreas Matthias. And in his book, Automaten als Träger von Rechten, Matthias makes the example of a smart elevator, an elevator that is capable of choosing in and by itself which floor to reach and when, according to the observed patterns in people behavior over a certain period of time. So you basically would install such an elevator in a building, and the elevator within a few days would learn that 8 o'clock in the morning everybody is on the ground floor and goes to the 20th floor, because on the 20th floor there is an office that opens just then. And then at a certain time in the day they all go for lunch on the 12th floor, and at some point at 5 p.m. they all go back to the ground floor. Now let's assume that one day somebody is feeling sick and needs to call an ambulance on the 12th floor at 9 o'clock in the morning, and the elevator is only going to the 20th floor, and there is no way of overriding the system to make it go to the 12th floor where it's needed, and that person suffers harm or even dies as a consequence of the impossibility for the emergency services to reach for him. Well, in that case, I would not hesitate establishing the liability of the programmer or the producer of that smart elevator, because even if the elevator learned by itself what to do, I would expect the programmer or the producer to anticipate the need for such a system to be controlled or overridden by a human being under conditions of emergency like those described. So would want to have an emergency button that allows the elevator to operate normally, or for a human being to resume control of the system or to stop the system. And anyway, even the very choice of giving that learning capacity to the system isn't a choice that was not strictly necessitated. And for instance, the programmer or producer could have conceived an alternative system to manage the functioning of the elevator. Maybe less sophisticated, but not necessarily so. Eventually even a form of supervised learning or centralized learning. But anyway, none of these should exclude the liability of the human being behind him. And the argument of the so-called liability gap, therefore, does not hold true. So finally, for the time being, we can safely say that the producer or the programmer are always responsible for any accident caused by an AI system, an advanced robot, or any other form of advanced technologies, because we can apply a but-for test, but for the programmer, but for the producer that gave the system those kind of capacities. Those systems would not be capable of doing what they actually did, and therefore even cause harm. This doesn't mean that the current legal framework is the best legal framework possible. Actually, there are a lot of shortcomings in existing relevant norms, and those need to be addressed. And the European Union is trying to do something about it. We will see what it is that they're trying to do and whether that works or not. Let me clarify a few more points. The first one, from now and then, a concept is recalled, that is that of electronic personhood. It was presented for the first time by the European Parliament in one of its proposals in 2017, February 2017. Now this idea has been disregarded, but it might emerge again, and it needs to be kept distinct from all I said up until now. Because some people misunderstood the notion presented by the European Parliament with the wording electronic personhood as the attribution of robots and AI system of rights as if they were living things, human beings, or anyway agents, in the sense that I have just clarified and excluded that could be deemed correct. However, there is a way in which this notion of electronic personhood could actually make sense, and that is if we understand it in a purely instrumental way. Electronic personhood could be deemed similar to what is typically the position of a corporation, namely a legal person, which is not attributed rights because it is deemed a living entity or deserving protection as if it were a human being or some animal, but just for instrumental and functional reasons. We attribute corporation legal personhood because corporations operate on the markets, and we want to simplify the contractual relationship. If the corporation is identified as an entity in and by itself, legal relationship with potential customers, suppliers, shareholders are all simplified because there is an intermediate legal entity, and you do not have to make all the shareholders interact with all the suppliers all the time when they want to enter into a contract, with all the employees when they want to hire a new employee, and with all the customers. But you simplify legal relationship radically. Another reason why we want to have corporations is because we typically apply corporations different tax regimes from single individuals. So tax reasons justify treating corporations as a separate entity from its shareholders. And also we separate corporations in order to achieve the separation of assets, meaning that the assets of the corporation are kept separate from the assets of its shareholders, which means that if I invest in a company, I'm only risking the amount of money that I have decided to invest in that one company and not my personal wealth. This segregation of capital is an essential function of a corporation, a reason why we want corporation to be treated as a separate entity. Now, we could apply an analogical reasoning to an analogous reasoning to advanced technologies and advance the notion of electronic personhood in this sense. That would not entail attributing AI systems or robots rights, duties, or obligations because we deem them to be agents, because we deem them to be deserving of such a treatment, but just for purely instrumental reasons. We might want to be able to register an AI system that is functioning on capital markets, investing and trading stock, derivatives, and the like. And that would be for purposes of transparency. And for such purposes of transparency, we might want to register it as if it were a corporation, and therefore we might want to attribute it legal personhood because of that. We might want to attribute legal personhood because this AI system is capable of generating art or contents that have a value, and we want to distribute cash flows to a multiplicity of people that are involved in the creation of the algorithm, in its training, its use, and therefore we might want to create an intermediate entity whereby the cash flow generated by these IP rights is attributed to the system, and then, only then, distributed in different percentages to the different subjects that are involved in its functioning, as if it were a corporation. So for these very functional instrumental reasons, we might want to deem an AI system an artificial agent in the sense of attributing it electronic personhood without ever admitting to the fact that that would be on ontological grounds whereby the robot or the AI system is similar to a human being or similar to an animal, and on the one hand deserves to be protected and deserves to have rights attributed to it, and on the other hand it also needs to be made responsible for its functioning and actions. Finally, if this is the case, if AI systems and machines are all to be deemed things, products, the current existing regulatory framework at European level, which is the most interesting level of analysis we will take into account, may be divided into there is a body of norms that is the so-called product safety regulation that most engineers and those researching technologists will be familiar with. It's those set of norms that establish the minimal requirements that any system, any products need to meet in order to be certified, in order to see the CE marking be applied to it, and therefore to be lawfully sold on European markets. And then there is product liability rules, and in particular the so-called Product Liability Directive, that holds the producer liable for all damages deriving from the use of their product on objective grounds, meaning without the need to establish the fault of the producer when something goes wrong, but only the defectiveness of the product. And even if you do certify your product according to product safety regulation, even if you meet the requirements laid out by those directives, regulations, and standards, international standards typically, that does not exempt you from liability if later on somebody using your product still suffers damage as a consequence of the defectiveness of your product. So the effectiveness of your product being the fact that your product behaves in a function that is deemed to be not correct, not safe, not corresponding to the safety that one would expect of a similar product under those similar circumstances. So even if you have certified your product, that does not exclude the possibility that you'll be held objectively liable for any damage that your product might cause, so long as your product might be deemed defective. And I will close this first class for now and invite you to follow the next one that will dive into the details of the existing and emerging regulatory framework at European level. Thank you.